Today on 21st Century Television, join us as we explore innovative technologies, cutting-edge solutions, and timely discussions from leaders across the globe. This is 21st Century Television.
Welcome to 21st Century Business. I'm Jackie Bales. In today's commercial disputes and regulatory investigations, there are enormous volumes of potentially relevant information that need to be collected, traversed, and managed. Well, needless to say, it's simply too labor-intensive and expensive for lawyers to eyeball every document when there are millions of electronic documents at hand. Here today to discuss this challenging topic and the solutions her company has created is founder and CEO of EDT, Joe Sherman. Welcome, Joe.
Thank you, Jackie.
Joe, tell us more about the challenges law firms, corporations, and court systems face when it comes to discovery and document management.
The biggest challenge is the new paradigm. Information is no longer in paper form. It's electronic. And this challenges the way lawyers work, it challenges the way they service their clients, and it even challenges their billing models.
So tell us a little about EDT and what you're doing to tackle these massive issues.
It may be relevant to say that I was inspired to establish EDT back in 2002 when I was engaged as a consultant to a top-tier law firm to help on a litigation project. And one of the first things I observed was the fact that there was a team of people committed to the printing of emails, an enormous volume of emails. There was a second team responsible for the scanning of those emails. And a third team of paralegals were engaged in the task of classifying that paper version of those emails in terms of to, from, re, title,
Wow.
which is all getting manually classified. This was obviously crazy. I observed the process in disbelief and thought there's got to be a better way.
Right.
Particularly because most of that material was largely irrelevant to the case, which meant that the costs were enormous with limited benefit to the client at the end of the day.
Well, be forewarned, we're taking you to court, but don't worry, you won't need an attorney. We're going to take a look at EDT Software and their solutions at work in the Australian court system in this 21st Century Business Field Report.
New Legal chose EDT to form the core part of the e-trial solution. We find that it's the most flexible and customizable courtroom software product on the market. We're also finding that more law firms are using it as their e-discovery system in-house. And we're finding that means that there's a very seamless transition between discovery and trial. In a couple of recent e-trials that we've run, judges have found that it's reduced the time of the trial by between 30 and 50%, just due to the time taken to seamlessly, more efficiently move through evidence in electronic form.
It's exciting for companies like New Legal and EDT to be working in this space and seeing the trend towards the use of this technology in small civil matters and in criminal cases where traditionally it hasn't been cost effective to implement technology. Now this sort of solution is so affordable and accessible, it's absolutely possible to deliver it in such situations.
In litigation of any scale, the major contributors to the length and the difficulties associated with running a case are always time and money. They're always finite, so any efficiency, any innovation that can try and maximise the value out of all the time and the money that's spent on litigation is welcome and really absolutely essential. Increasingly, lawyers are bringing less paper into the courtrooms and they all want to continue to do so. So it would be wonderful in the not too distant future to walk in with a hard drive or a laptop and that's all you need to bring. And I'm sure that many judges who get inundated with mountains of paper would like the same thing.
Everybody's familiar with email threads. Oftentimes in our data sets, there are 50 different employees who are on an email thread. So through the use of technology, we can collapse all of those email threads so that only the unique content is reviewed and only reviewed once, rather than a lawyer having to review 50 different email threads that are actually the same thread. They're just further down in the chain. So that's an example of where we use technology to make the review a lot more efficient. Really, what we're trying to do is allow the corporation to be more profitable. I mean, you think about it, if they're spending less money in their lawsuits and their investigations, they're going to be more profitable. It's going to allow them to pay higher wages and invest in the community because they're going to have more money to invest.
Joe, why has the discovery process become so expensive?
Unfortunately, what has happened in the e-discovery sector is that solutions have evolved over time that are so complicated and so over-engineered that clients really don't understand what's going on and they're afraid to question the costs. This has been further complicated by the fact that we're now dealing with big data, massive data stores. So the inefficiency is escalated exponentially.
Incredible. Now, I thought technology was supposed to make life easier and more efficient with all of our emails and all, but that's not proving to be the case.
Indeed, it should. In fact, I was inspired to pursue a career in the application of technology to law with that end game in mind. However, in e-discovery, unfortunately, instead of applying technology to make things more efficient, technology has often been applied to churn irrelevant, enormous volumes of data, which leads to exponential cost increases and enormous frustration for clients who really don't understand what's going on.
So the aim is this little tiny email might possibly be relevant, so let's do that one too, and this one, and this one, and this one.
Absolutely. Let's make sure we leave no stone unturned.
So why does litigation have to involve so many movements of data? Why is it so complex?
What has happened is that a myriad of software tools have developed over time, each with a specialist area of expertise, which is, I suppose, great in a sense, in that we have specialist tools and software products throughout the whole process. But this means that data is being moved around from one tool to another throughout the life cycle of a case or an investigation. That becomes very complicated. It requires specialist expertise and skill, and it dramatically increases the cost.
Now, you say EDT offers an integrated platform. What do you mean by that?
Effectively, what we've done is we've combined all of the necessary functionality to support the entire workflow for a litigation case or for an investigation. So from the initiation right through to potentially presentation in court, everything is managed in one place. So this means that it's a simpler to operate solution. It's consolidated and integrated. There are no data movements, and there's no need for particular expertise to move information around from product to product.
Well, it sounds like there are many benefits that this integration delivers. Can you elaborate?
One of the benefits, the major benefits really, is the flexibility that this solution delivers, in that it's possible to adjust as issues change throughout the life cycle of a case or investigation. Witnesses can change, timeframes change, and having a flexible technology platform that enables these changes to be implemented without going back and rechurning data or reprocessing is a critical opportunity for efficiency.
And why is litigation today so much about the discovery process?
Unfortunately, what has happened is the process has overtaken the outcome. What has happened is that the e-discovery exercise has become an end in itself rather than a means to an end. And that's because of the complexity and the industry that has been built up around it. It doesn't need to be that complicated. It doesn't need to be that expensive.
What about corporations? How have corporations been responding to your solutions?
We love working with corporations. Corporations generally are concerned about outcome and results.
So they don't necessarily want to spend the maximum dollars to read every tiny little piece of paper.
Absolutely. They're prepared, exactly, they're prepared to invest in technology that will deliver the results. And they're not concerned about preserving archaic, entrenched practices that reward inefficiency.
Now, conversely, many law firms make a lot of money from the review of large volumes of information, billable hours. Does the EDT solution challenge this traditional law firm arrangement?
Sometimes that can present some challenges for us. I remember a seminar a few years ago where we delivered a presentation, and one of the lawyers actually said, well, if this means we're going to be increasing our throughput, it just means I'm going to be charging less.
And we wouldn't want that.
So why should I embrace it? Which was quite depressing, really. But it does highlight the fact that the clients that we work with, the law firms that have embraced our solution, are outcomes oriented. They're interested in delivering value for their clients. They're interested in establishing long-term sustainable relationships with their clients because they deliver commercial outcomes that are realistic and in line with the client expectations.
Over time, it would seem like the pendulum would swing
That's
toward
right.
your way.
Absolutely. Best practice is emerging. And now many corporate clients in particular are becoming a lot more savvy and are starting to ask the right questions, which is something we very much welcome.
Now, you mentioned corporations, and the corporations love using your software. How are they using your software before litigation even commences?
We're finding that it's increasingly important to be on the front foot before litigation starts or before an investigation is anticipated. Those organisations that really get their information into a good state and get organised in advance have a massive strategic advantage when the day comes to actually pursue or defend some litigation. We've decided to partner with a software company that delivers some really smart technology to enable the review of documents to take place so much more efficiently. What this software does is it actually learns as an expert lawyer is reviewing documents, it learns a little bit about the decisions that they're making and gets to a point where it actually is trained to simulate or replicate that lawyer's thinking. This technology can then be run across a massive data set to make an assessment about the likelihood of any particular document being relevant to the case based on the learning that it's undertaken. We think this technology is very exciting. It's the way to the future in terms of dramatic reduction of costs, because it doesn't necessarily mean we're going to replace lawyers. That's often the fear when we talk to lawyers about this. It's not going to replace lawyers, but it just helps them to work smarter and more effectively because it prioritises the documents for review so that they're looking at the documents that are most likely to be most relevant more quickly, which means cost savings. And the way we've integrated that within our total workflow, again, delivers savings across the board.
Thank you so much, Joe, for joining me on the show today and for sharing with us these useful solutions you're providing at EDT. It's fascinating.
Thank you. Thanks, Jackie.
For 21st Century Business, I'm Jackie Bales. Thanks for watching.